Welcome. My name is Paolo Annino. I'm with FSU College of Law, and I'm talking today about special education law. And we just completed our 6-part discussion of special education law, and in cyberspace we received 5 questions. So this is our Q&A session right now. The first question is, generally, what steps need to be taken before an individualized education plan can be put in place? Again, generally, what steps needs to be taken before an individualized education plan can be put in place? Well, first thing, it should be put in place immediately, right? You know, an IEP, individual education plan, is for 1 year, and it has a beginning point and a duration point. So it has a beginning and end point. So it should be put in place immediately. What I do recommend sometimes, especially for middle school and high school children with individual education plans, what I do recommend is each one of the child's teachers, because in middle school and high school, the child will have many, many teachers for different subjects. For the different subjects, rather than just sending the teacher a copy of the child's IEP, is actually sending an email or a letter summarizing the main points of the child's IEP, in addition to sending a copy of the IEP. Because you want to make sure that the IEP is implemented. There's no point of going through this whole process of going to IEP meetings, going to administrative hearings, going to appeals, if the IEP is not being implemented. So, and who's going to be implementing it? Who's, boots on the ground? That's the teachers. The boots are on the ground, it's the teachers. So it's important that the teachers have a copy of the IEP. It's important that the teachers understand what the IEP says. It is, I think, a good practice for a parent or advocate to actually meet with the teachers to make sure the teachers understand the IEP, make sure the teachers understand what the agreement is. So to answer your question again, it should be done immediately, and my recommendation would be is making sure each one of the teachers has a copy of the IEP, that you send a letter or an email summarizing it, and if you can, actually visit with the teachers. Now, for elementary school teachers, the teacher usually was present at the IEP meeting, but again, it doesn't hurt keeping in touch with the teacher to make sure that she understands or he understands what the agreement is all about. Because the teacher is seeing a lot of different kids, so it's important that the teacher gets educated about your particular child. So that's my answer to the first question. Now we're going to turn to the second question. And this is the first one was a good question, the second one's a really good question. Are there any assessments that could be done by the dependency court that would speed up the process for accommodations and or modifications for a child? Again, are there any assessments that could be done by the dependency court that would speed up the process for accommodations and or modifications for a child? Well, a couple points. One is, there's the Individuals with Disability Education Act, and we talked about the 5 basic parts of that act, components of the goals, the present level performance, related services, least restrictive environment, and present level performance. We talked about those, but there's also a section in there dealing with modifications and accommodations. Earlier today, we talked about in Section 504 of the Rehabilitation Act, where that document is primarily just dealing with accommodations. So, assuming that the question applies to both, is there any way of making that would speed up the process? Would speed up the process? Well, that's difficult because initial evaluations have to be done within 60 days, but the law does not specify how long a school district has to do reevaluations. And I agree. some school districts really drag their feet on these reevaluations, and they take many months. And I would like to speed up the process. Dependency court judge can order evaluations, and those evaluations can be used at a IEP meeting. It can be used at a 504 plan meeting. However, the school district is going to want their own evaluation. So yes, I do recommend that you ask the foster care judges to order specific evaluations that will benefit your child, but whether or not that would speed up the process is another story. I think it might make your case stronger, but I don't know it will speed up the process simply because most of the school districts want their own evaluation, and there is no other time limit except reasonable. And courts have gone every which way with what's reasonable. Okay, now let me go to the third question. The third question is, what is the process for enforcement of IEP provisions if a GAL discovers they are not being met? And what is the statutory provision for such enforcement? So let me read it one more time. What is the process for enforcement of IEP provisions if a GAL discovers they are not being met? And what is the statutory provision for such enforcement? Well, as we talked about, we create this document, the individual education plan, and the document embodies a free and appropriate public education. If you discover it's not being implemented, so the document is not being implemented, what do you do? Well, there's different lawyers who would respond differently, but I think the best thing to do, if you discover it's not being implemented, that you immediately contact the school and ask for a IEP meeting to discuss the failure to implement the IEP. So I think the fastest way of resolving this problem is bringing it to the school's attention, asking for a IEP meeting, ask the implementation. And that way you'll get the school district's immediate response to what you're claiming is not being implemented. I know myself, there was an IEP where it said the child is to be in special education gym. The child was to be in special education gym. And it turns out that the child was not in special education gym. The child was in a regular gym class. Well, yes, I could have gone to an administrative hearing on that issue, but it was much faster dealing with it just by asking for an interim IEP meeting, where as soon as the school officials realized that they dropped the ball, they then worked in trying to fix the problem. Like they placed the child in a special gym class. So I think the fastest way of dealing with the problem is by asking for another IEP meeting as to implementation. Yes, there is another way, and that is just simply filing a petition with the school district and the Department of Education that the child is being denied a free and appropriate public education because of failure of implementation. But I do think the fastest way would be bringing it to the school district. One other comment I want to make, which I didn't talk earlier about, was something called compensatory education. So if you do go to an administrative hearing and you win, one of the things you can ask for is compensatory education. That's education to make up for what you lost. And the same thing I would say in the case of going to an IEP meeting on the issue of implementation. If they failed to implement it, you could, in addition to getting them to implement it, you could ask for compensatory education. Okay, let me turn to the next question. Okay, what forum is appropriate to litigate disputes over accommodation/modifications? Dependency court, administrative hearings, civil court. What forums is appropriate to litigate disputes over accommodations/modifications? Dependency court, administrative hearings, civil court. Well, I think for both IDEA and for Section 504, the first step is resolving it, trying to resolve it at either an IEP meeting, if it was an IDEA case, or a 504 plan meeting if it's a Section 504 plan case. So those two mechanisms, a 504 meeting or an IEP meeting, that should be your first way of trying to resolve the dispute. If that fails, then the next step is going to the administrative process. And for IDEA, that administrative process is DOA, a full-blown administrative hearing. For a Section 504 dispute, the administrative process is the school district either will do the hearing in-house or they can contract with DOA. And if you have a say of the matter, you want to always contract with DOA, because with DOA, you have expert attorneys who are judges who are impartial. Whereas if the school district does the hearing, what usually happens is they'll create a subcommittee and one or two school board members will be the judge. And the whole problem with that is what I call local cooking. I mean, the whole problem with that is bias. So it is definitely better to go to DOA if you have the opportunity to. And yes, the vast majority of cases can be resolved at DOA if they're not resolved earlier. And then we saw earlier at the IEP stage, or at the 504 stage, or under DOA, under the IEP, we talked earlier about a resolution meeting. And what I'm finding around the country is a lot of IDEA disputes are being resolved at these resolution meetings, which is really like a super IEP meeting. What about, the answer is foster care court. Really, the truth is, I don't think that's the appropriate forum. That I think you could use the foster care court to create and get the judge to order evaluations, but really the mechanism, the forum, is administrative hearings, either these IEP meetings or 504 meetings, or DOA, or with Section 504, it's either a school district or DOA. So again, yeah, I would not recommend circuit court. I would not recommend foster care court. If you lose at DOA, my recommendation then is you go right then to federal district court. So that's the avenue for an appeal if you lose at Department of Administrative Hearings, both for IDEA and for Section 504. Now the last question is a mouthful. Okay, so it's going to take me a little while to read the question. Okay. Also the previous question they asked, what is the statute? What is the statute number that they should look at? The statute number for in Florida dealing with these issues is 1003-57-1C. We'll talk about the right to appeal and to the Department of Administrative Hearings. Okay, here's the final question for today. What recommendations do you have when a child is on the 504 plan and you are advocating for special education services and an IEP, and the child is working below their peers in class, but the school team says the child is showing improvement by using the interventions of the 504 plan per their data review? And since there is improvement in this child's progress, having been using third-tier interventions, the child does not qualify for ESE services. In this case, the former dependent child has been diagnosed with autism, is able to function, is polite, but works below her peers, leading to a discussion that the child would be retained in the second grade but was promoted? This question has a lot of parts to it. The first thing is this whole issue of 504 versus IDEA. 504 504 is a one-pronged test dealing with, does a child have a disability? Yes or no? And a disability is defined as an impairment that substantially limits a life function. Whereas IDEA is a two-pronged test. You have to have a categorical approach, meaning a category, and autism, by the way, is one of the categories for IDEA. And the disability has to have an adverse effect on the child's education. So, an advocate has to decide this. I mean, in this case here, it sounds to me from this question that the child really is an IDEA child, because if the evaluations show that it is because of the child's autism, the child's having an adverse effect on his or her education, then the child is an IDEA child. And what needs to happen then is you would go to an eligibility team meeting, which is like an IEP meeting. You would again do an eligibility team memo spelling out that the child does meet the category of autism, and establishing through evaluations that it is the adverse effect of the based on the autism that's causing the educational deficits in this case. So it's the autism that's creating this adverse effect in the child's education. So you would go to an eligibility team meeting. There's an impasse. You have a right to an administrative hearing. With DOA, you file a petition with DOA, and you file a petition with Department of Education. Within 15 days, the school district transfers the petition to DOA, and then there's a hearing. And in between that, there's a resolution meeting. And hopefully at the resolution meeting, you'll be able to persuade a school district that there is an adverse effect. But if you can't persuade them, then you go to an impartial de novo hearing officer. And as we began earlier today, I said evaluations, evaluations, evaluations. And that's really what it comes down to. Do your evaluations establish that autism is having an adverse effect on the child? So thank you for spending the day with me today going over special education law. If you have any questions, again, on special education law, and you're part of the Guardian Ad Litem program, you can feel free to contact me. You just look up FSU College of Law, Paolo Annino, and you'll easily be able to get my email. So thank you again for the hard work you're doing for our foster care children in the state of Florida.